A warm welcome to all. Thanks for joining our IP Playbook for Going Global, jointly organized by SG Tech, IMDA, and IPOS International. Taking your business overseas is an exciting yet potentially risky affair for business owners. What's critical to success is having a strong IP position that empowers business leaders to capture new opportunities while avoiding costly mistakes. So to help you along in your journey, we have invited Eric Koo from IPOS International to share insights into the best practices and tips of owning and protecting your most valuable assets. We will also learn from case studies of Singaporean companies who have ventured abroad. So before we begin, we would like to highlight some house rules for this session. Firstly, a gentle reminder that the webinar will be recorded for marketing and archival purposes. The recording will be uploaded onto a SGTech's website. Next, you can also type your questions in the Zoom Q&A box throughout the webinar. Selected questions will be answered. Please state your company name as well as your name before asking the questions. So Eric heads the Global Engagement Business Development at IPOS International, where he manages its overseas expansion. Prior to joining IPOS, Eric was with Reuters and HP, holding various positions surrounding IP consultation, IP portfolio management, and also technology licensing. Eric graduated with a bachelor degree of engineering from NTU and also holds several certificates in Intangible Assets Management and also a graduate certificate in IP issued by IP Academy and NUS. He has also spoken at many high-level industry conferences and is an established thought leader engaged with other key opinion leaders in IP research and discovery. So let's welcome Eric. Eric, please.
Thanks so much, Ying, for the very kind introduction. Okay, so let me just start my slideshow and let me know whether you can actually see the slides. Okay, can you see my slides?
You need to click the slideshow mode.
Okay, give me a second, yeah?
Yeah. Change the display settings.
Okay. This is the correct view?
Yes.
Okay, good. All right, very good afternoon, everyone. So thanks to Ying for the quick introduction about myself. So I'm Eric, and I head the global engagement business for IPOS International. And I was just enjoying the Christmas music earlier on that they were playing. So timely reminder that we're coming towards the end of the year as well. So merry holidays and a very good Christmas to all of you in advance first. Yeah. Okay, so today's topic is going to be IP Playbook for Going Global. And I thought I would just start off with a quick introduction about who IPOS and IPOS International is first, for those of you who are actually not familiar with us. So IPOS is actually short for the Intellectual Property Office of Singapore. So we're actually a government agency that's under the Ministry of Law, and we are the agency that if you want to file for a patent or trademark or design registration, that is the agency that you actually need to go to. Now, for myself, I'm actually from IPOS International, which is a wholly owned subsidiary of IPOS. And within IPOS International itself, we have about 100 experts under one roof, and we are more of the expertise and as well as the enterprise engagement now of IPOS. Now, to give you a bit more context about what IPOS International does. So we are basically structured into three pillars. So if you take a look at the leftmost part, right, that's basically, I would say, the consultancy arm. So we do actually assist with a lot of companies, especially small, medium enterprises, in helping them to actually come up with their IP strategy. So how do you actually leverage and use your intangible assets to grow your company? And in the middle portion is we also have a patent search and analysis capability. So, when you file a patent application, it actually needs to go through a whole examination process. So that's where the expertise lies. And with this expertise, it also allows you to actually understand, to say you want to find out, for the big companies out there, what kind of innovations they're coming up with, which countries they're actually focusing their resources and R&D efforts in and so on. So we do have the expertise to actually help to uncover this kind of insights. And on the last pillar is actually on the training and education portion. So within IPOS International, we carry out a lot of different kinds of trainings, anything from half-day sessions like this one right here, which we have also, all the way until to a 2-year part-time master's program, which we actually co-organize together with the Singapore University of Social Sciences. So if you're interested to find out more about, IP in depth, right, you could actually attend some of the courses. Okay, so enough of the advertorial for who IPOS and IPOS International is. I just wanted to start today's presentation with a bit of a primer. So understanding what actually intangible assets are. And to do that, let me do a very quick differentiation first. So to differentiate what is an intangible asset versus a tangible asset. Now, so for tangible asset, as the term implies, it is actually something that you can actually touch, see, feel. So things like your cash, land, equipment, machinery, furniture, and so on and so forth. Whereas for intangible assets, those are items which are typically not so touchy and feely in that sense. So things like your patents, trademarks, copyrights, your customer lists, employment contracts, and so on. Now, there are also a lot of other, I would say, differentiating factors between tangible and intangible assets. So as we mentioned before, tangible is something that's more physical. The other part is that because it's a tangible asset, it can actually be destroyed by forces of nature. So for example, if you have a fire, a flood, and so on, your tangible assets can get destroyed, but intangible assets cannot be destroyed by physical forces in that sense. And I would say the very key important differentiating part between tangible and intangible assets is the ability to be used by a single or multiple party. So if you take a look at tangible assets, for example, let's use a piece of land to illustrate this. So you have a piece of land, you can actually build a factory or a house or whatever it might be, depending on the zoning requirements, right? But once you build that particular infrastructure over there, that's limited for that particular use. And you can only have, one party, or you could have different multiple parties using it, but it's kind of like at any point of time, there's only one particular usage for that piece of a tangible asset. Now, versus if you look at intangible assets like a patent, for example, you can have one single patent which can license to multiple parties at the same time. And your license to the different parties can also be, I can license you for a certain usage, and you can actually craft out that particular usage to do that. And in fact, multiple parties can even have the same usage of that same patent. And you just need to actually have inside an agreement to say that what are the rights that you actually have to that particular patent, for example. So this is a very powerful concept in that intangible assets are something that you can actually scale, and you can allow multiple parties to use at the same time. So that's a very powerful concept about intangible assets that I'd like to kind of share with you. Okay, so moving on. There are many different kinds of intangible assets, and one subset is what we call your IP assets. So those which are the orange bubbles at the top, right? And the top left three most one, the patents, trademarks, and designs. Those are the ones that you actually need to register. So that means you need to, if you want to have them protected in Singapore, you need to actually register them with IPOS. And the next two bubbles, the orange ones at the top, copyright and trade secrets, those don't actually require registration. Okay, so generally IP assets are those that you actually require a registration. Now, so what are the differences between all these different kinds of IP assets? So a patent is basically an exclusive right that's actually granted for an invention, which is, I would say, for a product or process that provides a new way of doing things or provides a technical solution for a problem. So it's very technical in nature for patents. Whereas a trademark is essentially a sign that's capable of distinguishing the goods and services of one company from another. So McDonald's, for example, you take a look at the golden arches, you know that, okay, this is a place where I go to for burgers and shakes and so on and so forth. And as for designs, this is actually related to the visual appearance of a product. So Apple, for example, before the iPhone actually came out, almost every other phone out there in the market has got a display screen and actually has got a physical keyboard. But when the iPhone came out, it was just a plain screen and nothing else. So that was revolutionary at the point of time. Okay, so design, just remember, it's something that's about the outward appearance, and it's typically used for things which are more aesthetic in nature. So for example, your mobile phones could be also used for jewelry protection and so on. So design registrations have got nothing to do with the functionality of it. The functionality part is actually protected by patents. Okay, so for copyright, it refers to the rights that creators have over their literary and artistic works, and quite a number of different kinds of works fall under this category, which can be from books to music to paintings to sculptures to computer programs, databases, and so on. And finally, of course, for trade secrets, everybody knows, for Coca-Cola, what actually goes inside the ingredients till today is actually still top secret. So trade secrets are generally something or information that's actually not divulged to the public. Okay, so now if you take a look at the bottom part of the screen, right, which are those in the purple bubbles, these are what we call a larger set of what we call intangible assets. And you may be aware of them. It's just that perhaps you have not thought about them as being part of intangible assets. So for example, know-how with a consultancy company like McKinsey & Company, the know-how actually resides within the knowledge of the consultants themselves. And if you take a look at the next bubble, General Electric, GE, right, they're very good at implementing system and processes. So they have done this with so many different companies. They know what is the best practices that they can actually bring to a next company that comes to them for help. And the next bubble, if you are a drug company like Pfizer, regulatory approvals are one of the key sources of intangible assets, because if you don't get a regulatory approval, you cannot actually start to market and sell your drugs. And of course, there's domain names and data for Google and so on. So just would like to introduce this concept that intangible assets are something that's residing in a lot of companies. It's just that if you don't actually actively look out for them, you may not be aware that they're actually existing in the company. So now that we've talked about the concepts of intangible assets, right? Just bear in mind that they don't have to work separately. They can actually work in tandem in a single product. So like this screen that you see right now, an espresso machine, right? There's multiple kinds of intangible assets in there. So from the trademark, which is the logo of the Nespresso, to the milk frother, which is the black color cylinder that you see, that's actually protected by registered design. So how it actually looks, to how you extract coffee from a capsule. So that's actually protected by a patent. To your marketing brochures, which is protected by copyright. And then, within the capsule itself, it's actually a trade secret, which is the blend of ingredients that actually goes into it. You may know about the constituents, for example, but you don't know exactly how much of each percentage of it goes into it. So how much of it is like, say Robusta coffee versus Arabica, and how much of the skim milk actually goes into it as well. So that's actually a trade secret that you don't know about. So as you can see, in one single product, you can have multiple intangible assets that actually covers it. Okay, so this is a table to give you a very quick overview about, we mentioned about the different kinds of IP. So this chart gives you like a quick overview to say how easy are they to protect, how long the duration of protection is, the scope, and of course to the cost. Now, if you take the top, look at the top bar, right, which is copyright, they are the easiest to protect in the sense that the moment you actually manifest your copyright into, say, an actual writing, so that means you condense it into form, or you actually start to perform, you actually put it down in writing, you actually type it in the computer, the copyright actually starts to exist already. Okay, so that's the easiest form of protection. And the duration is one of the longer ones. So it's actually life of the author plus 70 years. So that means after the demise of the author, right, you have another additional 70 years that will actually continue to for copyright protection. And the cost to obtain, it's practically zero. And of course, there will be some costs, and I'll mention about this later on in the slides, but just remember that this is one of the easiest form and practically almost no cost to protection. Now, if I move down the chart to the most complex one, it's probably going to be a patent. It's going to be difficult to protect simply because in drafting a patent application, it requires quite a fair bit of technical skill. So you usually go to a patent attorney to actually help you to draft a patent. And duration is actually for about 20 years, of which I would say quite a number of years is actually in the application process. So for a patent application to go to grant, depending from country to country, you can be anything from, typically it's about between 3 to 5 years. So for the 3 to 5 years, while your patent is still in a pending stage, it has not granted. So until it's actually granted, then that's where your powers actually come in. So for 20 years, that's the typical protection time for a patent. And the cost to get a patent protection is on the high side, actually. And again, I'll discuss about this later on in my slides. So this chart just gives you a very quick condensed view about the different kinds of IP and the cost and the duration of it. Right, so if you recall, we talked about the Nespresso example previously, right? So think about that. Would it be easy for you to replicate the business model? In order for you to actually replicate the Nespresso business model, right, you need to think whether it's easy for you to bypass the patent and the design registration and protection and so on and so forth, right? So really this chart here is to show you that strong intangible assets represent a very strong barrier to entry. So once you have a strong barrier to entry, this allows your company to actually price the product at a premium and maintain your lead in the market for much longer time. So a successful product with strong IP allows you to price at a premium for a longer period of time. If you have a successful product but a weak IP, then you can charge for a premium, but your product will not be able to actually sustain the sales for a long period of time. So really, intangible asset presents a barrier to entry for your competitors. So that's one very key important thing that intangible assets can bring to your business. So we talked a lot about intangible assets and how they can actually bring value to a business. And I want to bring across this new idea, which is the idea about this innovation cycle. So a lot of times we think about innovation as maybe, a light bulb moment and something comes up and you use it and you make money from it. But in fact, innovation shouldn't be a one-off moment. It should be in a continuous circle. So let me explain a bit more about this innovation cycle. Innovation is something that has got to go into a cycle, and the protecting vehicle in it is actually what we call intellectual property. So IP shouldn't be just about law. It has to do with business as well. So that's one thing that you also need to take note of. Don't think of IP protection as something that you actually tell the legal counsels or your legal department to look at. It's something that's actually should be infused within the whole organization and with different departments as well. So I would like to share with you this definition of innovation, which is from the Organization for Economic Cooperation and Development, or OECD for short. Their version of the definition of innovation is about taking ideas to the market. Okay, so if an idea, no matter how groundbreaking, how fantastic it is not brought to the market, right, then there is no socio-economic impact. So in order for innovation to exist, right, it has to be brought to the market. So we did a study about the most innovative companies and countries, and it seems that this innovation cycle that we are showing here seems to be a very common form of this innovative companies and countries. So you typically will start with an idea, and then from your idea, you have your ideation and your conceptualization stages, which you then produce your IP and intangible assets. This then gets put into your products and services, which you will then actually start to commercialize by selling your products and services or working with somebody else. And once you get the revenue from that, you have to actually then reinvest into creating new ideas. Okay, so as you can see, this is a continuous cycle of ideas into conceptualization, products and services, commercialization, reinvesting, and so on and so forth. And you see that in this whole cycle, right, IP is actually the vehicle which allows you to bring these different parts into this circle. And there are also many different parts or parties that you actually need to work with in the different stages as well. So my point earlier about innovation or your intangible assets shouldn't be something that you actually leave it to the lawyers. It should be something that is infused within throughout the whole organization. So whether you be in your conceptualization stage, you're working with a marketing or your product development team, in the product services development stage, whether you're working with the business development or marketing team, to commercialization, where you're working with your sales and marketing, manufacturers, brokers, and so on, and finally reinvesting again. So there are many different people that are involved in the whole innovation cycle. So again, just to re-emphasize, this is something that should not be, just something that's left to the legal because it sounds legalistic. No. So really, IP is something that's infused throughout the whole organization. So we did a consolidation of audit reports that we actually did for a couple of companies back in 2018. And we found that there are a couple of IA gaps of Singapore companies. And one of the key gaps, which is the one on the gray bar that you can see, 46% have incomplete protection of intangible assets. And the next one we see is that 25% of them actually lack IP knowledge, and so on and so forth. So really, we are at a stage where a lot of Singapore companies are still not very proficient about what actually is intangible asset and what actually is IP. And they're not putting in enough protection to safeguard these key assets that they actually have. Okay, so just to share with you some of these observations that we've seen while working in companies in the past. All right, so that's kind of like the background and primer about, the basics of IA and intellectual property. So the next part is that when you go overseas, really you need to take care of intangible assets. There's no other way about it. And in fact, not even going overseas, while you're still operating within Singapore itself, you also need to take care of intangible assets. Okay, for your IP elements, when you are planning them, right, you need to also work in together with your business planning. So a lot of times, again, back to my point earlier, business planning should not be separate from your IP planning. So this actually need to come hand in hand together. So for example, if you take a look at the business planning stage of identification of markets at the top right, that's actually where you need to start to identify your IP assets. When you develop a business strategy, you need to start to develop an IP strategy. When you actually look at market adaptation, you need to comply with local IP rules and IP protection as well. So your strategy for your IP management, it doesn't need to be very complicated. It again depends on what kind of operations you are. And it could be that it's a very minimal strategy, and that's fine. Because you may decide that your IP strategy is unlikely to actually affect your product or service development, manufacture, and so on. So maybe your focus would be actually then to reduce risk. Reduce risk in the sense that if you're moving into a new market overseas, right, you want to know whether you have what we call a freedom to operate. So that means bringing your products into a different country. Will it actually infringe on the IP of another party in a different country? So bear in mind that just because you can operate in Singapore freely doesn't mean that you have the same rights to operate somewhere else as well. Okay, so that's something that's very fundamental, because IP rights are very jurisdictional in nature. So what it means is that if you have IP protection in, let's say, Singapore, it does not mean that you will have the same protection somewhere else as well. And likewise, your competitors may actually have IP protection in their countries, but maybe not in Singapore. So you assume that you can operate in Singapore, and that's why you can operate in your competitor's country as well. So that is not true. So you need to actually conduct what we call freedom to operate searches to ensure that your products and services will not infringe on the IP of another party in a different country. So that's what we call a very minimal kind of a IP strategy to ensure that you don't infringe on somebody else's rights. And then we can go up a further ranking, which is then you actually start to become more defensive in nature. So defensive as in you are now actively filing protection for your own IP. Okay, so you want to ensure that nobody else actually infringes on your IP. So that's starting to be defensive. And then the next stage up, which is a bit more offensive. So that means now that you have actually have an audit about what you have in your company, you have actually protected them. So now the next stage is to think about how can I then actually leverage on this IP assets that I have protected to make further revenues for me. Okay, so that's more on the offensive front. Oops. Okay, so some of the questions that you might want to ask when you actually start to go overseas are, where are your key markets? Do you need distributors? Is it easy to enforce your rights in overseas, and so on and so forth? Now, again, the key point that you want to remember is that IP rights are territorial in nature. So just because you don't infringe on any rights in Singapore does not mean that you don't infringe on IP rights overseas. So that's the very key thing that you need to take a look at first. So when you expand overseas, make sure you don't infringe on somebody else's IP. And I mentioned about the concept of the freedom to operate search, right? Especially if you intend to expand for a technological kind of a product into a couple of countries such as the US, EP, Japan, China, and South Korea, right? These are what we call the key IP countries. You definitely want to do an IP search for those countries. Why? Simply because about 94% of patents worldwide originate from just these 5 countries. So if you do intend to do business in those few areas, right, you definitely need to do your freedom to operate search to make sure that your technological product doesn't infringe on somebody else's patent over there. Now, also, when you start to go overseas, you will need to also localize. And when you start to do a localization, there are considerations that come in place. So in a business sense, when you localize, it might be changing your product's name to suit the particular country. It could also be, if you have, like, say, an electronic product, you may have to switch the voltage to actually adapt to the particular country. So likewise for your IP rights as well. Let's say if you have a registered design for how your product actually looks, but you realize that if I move to a different country, that particular country may have a different market that actually has got a different need. So for example, yellow sells very well in Singapore, or that, a triangle shape sells very well in Singapore. But if I move over to a different country, they may perhaps prefer something that's actually more squarish in nature, or something that's more circular. So as you can see, the design registration protection that I have for Singapore would have to be different from the one that I moved to a different country. So adjusting to the local needs and the localization for the particular country will affect some of your IP decisions as well. So on getting the name correct, I'll be giving you an example in the next slide, so we can take a look at that as well. Okay, so if you take a look at this picture over here, so Carrefour is actually a very big French foreign supermarket. And when they actually started to launch into China, they had to come up with a Chinese name. So the Chinese name that they actually came up with is Jia Fu. And what that actually means in Chinese is that it's a happy family and a prosperous life. So it's got a very positive connotation to it, and it actually sounds similar to Carrefour as well. Now, on the flip side of it, this is an American electronics giant, which is called Best Buy. They also entered the Chinese market. So the name that they actually came up with is called Bai Si Mai. So Bai Si Mai also sounds a bit like Best Buy. It's just that when you combine the word Bai Si and Mai together, so in Chinese, right, the Bai Si actually sounds like best, but the meaning behind Bai Si means think 100 times. Whereas Mai is actually a literal translation of buy, which is buying. So Mai actually is the Chinese word for buy. But when you combine these two words together, even though they sound nice together, right? Bai Si Mai actually has the connotation of saying that think 100 times before you buy. So maybe that's not a very good thing to have in China when you're telling your consumers that when you come to me, you need to think 100 times before you buy, right? So as you can see, local contextualization is actually very important as well. And so when you start to expand into different countries, you might want to think about what your brand name might be in a particular country as well. Okay, so what do you look for when you actually expand overseas? It can be anything from, trying to get upstream, as in, you're sourcing for raw materials, you're looking for suppliers to help you to provide certain parts to your product, or you're looking perhaps even for, software developers or writers to actually help you to write your code and so on. to anything that's downstream. So that means you actually start to look at the distribution side of the house. Do you actually go into a JV? Do you actually sell your business over there? Do you set up your own presence? Do you go into licensing or franchising and so on? So in overseas, there are this couple of things that you might be looking for. And there are considerations whether you actually go upstream or downstream. So some of the upstream considerations, right, and how your intangible assets might actually be affected are those that you can actually see on the screen. So when you actually start to outsource your production to a third party and overseas, right, the quality of the goods can actually be affected, because right now you are depending on somebody else to actually produce your goods for you, and that affects your brand. And of course, your trademark that's associated with it, because if the manufacturer you're working with does not have a good QC system in place, then that affects your brand directly. And when you talk about, having to work with manufacturers or whether it's software developers and so on, you will need to impart certain kind of knowledge to them. So whether it's going to be your product blueprints, or whether you have to share with them certain kind of software codes in order for them to actually build on that further, right? You have to be very aware of that. This could possibly be some of your trade secrets or know-how that could actually get leaked by the party that you're actually working with. So you need to get into what we call non-disclosure agreements to say that, okay, if I'm going to share this information with you for the purpose of you helping me to produce something, then there's some information that needs to be kept within us and cannot be leaked. So non-disclosure agreements are something that's actually needs to be in place. And then on copyright, that's actually interesting, especially when you come to this region, right? So when you start to outsource some of your work to software houses that's outside of Singapore, you need to take note that in countries like Indonesia and Thailand, copyright works which are curated by an employee during the course of work or employment, right, is actually owned by the employee. So it's a very different position from Singapore, where the work that's actually created by an employee during the course of work actually belongs to the employer. So in Indonesia and Thailand, it's a bit different. So if you do outsource to these particular countries, maybe through a production house, you need to ensure that the production house has got, say, an employee agreement that they have in place with the employees to say that whatever work that the employee produces actually belongs to the production house. Yeah, so this kind of nuances you need to be aware of when you're actually dealing with different parties in different countries. Okay, so when you start to actually move downstream, what are your expansion options? So let me just very quickly click on all these animations for them to come up. Oops, sorry. Okay, so the typical easy way or the fastest way to actually get overseas is actually to join an e-commerce site or start an e-commerce site. So you just put your goods on a platform and you can actually start selling to many different nationalities across the world. And that's typically what we call, or we have a very simple IP arrangement, because you just need to be aware that you're not infringing on somebody else's right, and that your patents and your trademarks, if you have those in place, are actually protected. Versus if you start to go into regional trade shows, or you actually start to acquire a company in a different country, or you set up a subsidiary, or if you're looking at a distributor to help you to distribute your goods or franchises and so on. So the complexity of the IP arrangement actually gets more and more complex when you move from number 1 until a IP holding company number 8 at the extreme right. So just to give you a bit of idea about if you are looking at these different ways of actually expanding overseas, the complexity of your IP arrangements will get more and more complex from the left to the right. So we talked about the upstream considerations that will actually affect your intangible assets. Now let's talk about the downstream considerations. So now you're actually looking at distributors to help you to sell your goods and services, or joint ventures, or having a franchisee and so on. Then right now you're working with somebody else to actually help you to sell your products and services. So again, brand and trademark can be affected by whoever is now representing you to actually sell your products and services. And again, when you are sharing information with your franchisees or distributors and so on, you will inevitably also need to allow them to use certain parts of your intangible assets or IP, especially true for if you're actually working through a franchise. So you need to give them this information, but you also need to monitor to see how are they using your intangible assets? Are they using it within the rights of what's within the agreements, or are they actually using it for other purposes? So I would say policing is something that's actually very important. So having that constant oversight about what your partners are doing, that's very important. And of course, when you're working with a downstream distributor and so on, you will be giving them your product brochures, your marketing collaterals, because they'll be helping you to sell. Now, do they have then leeway to change your brochures? Can they use it wholesale? And how does it, how it actually will look and feel and so on and so forth? That's something that you actually need to put in place as well. So these are a couple of considerations that you need to have when you actually start to go into downstream collaboration with your partners. One other thing which I want to bring up is what we call a dispute resolution mechanism, whether this is going to be upstream or downstream. Because invariably, when in business, everybody hopes for the best and everything works out well. But if things don't actually work out too well, it's not always necessarily that you need to go into what we call litigation. So one party suing the other because something doesn't go well. You could also consider what we call dispute resolution mechanisms, which is can you, instead of going into litigation, go into dispute? Because certain countries might be more adverse to starting a litigation because that actually totally decimates your relationship. Whereas some countries, they are actually okay, you want to go into litigation, that's fine. So maybe dispute resolution mechanisms might be something that's more suitable in certain countries, and you might actually want to explore that. And there are some schemes available, which I can actually share with you later on in my presentation as well, to help you with using dispute resolution mechanisms. Okay, so this slide really just gives you a very quick overview about where the typical contracts where IP actually appear. So we talked about NDA earlier on. So that's where a typical contract might have IP actually appear in them. Employment agreements, that's another common one. So usually in an employment agreement, you want to ensure that whatever that your employee creates in his course of work belongs to the employer. That's typical. That's a very typical clause that you actually find inside employment agreements. And then between agency, franchise, and distribution agreements, so what kind of IP actually gets transferred to your agent, your distributor, or your franchisee? And in turn also, if they do start to produce their own IP, right? Does this actually get shared with you as the principal, or is it belonging to them? Because each party will be bringing your own IP. So this is what we call the background IP. And you may actually produce new IP moving forward. So that's called foreground. So for the foreground IP, who actually owns it? And who has the responsibility for pursuing protection of that? So that has to be something that has to be actually spelled out quite clearly as well. Okay, so there's many other different kinds of contracts, so manufacturing, IT, and so on and so forth. So I won't go into details about them, but just to give you a very quick idea about the typical kind of contracts where IP can actually appear in them. Right, so I wanted to share with you this example of a company that actually really practices, as in uses IP to actually help them to grow, and is in every step of their way using IP to actually protect the company as well. So Ms. Buck, which is the lady in the picture on the left, right? She's actually the founder and managing director of Hagen. And she came up with a unique square container that has got 3 functions built into it. So the bottle actually allows mothers to express, store, and feed using a single container by simply swapping the bottle's feeding head. So if you remember, or if you actually see in the market, right, most milk bottles are actually round in nature. So this one is a bit more like a square shape. So that's a bit different to start off. And most milk bottles out there in the market requires what we call a screwing action in order for the top to be screwed to the bottom. Whereas for this particular bottle, it's just a very quick press of a quick release button and the top can be taken out. And just to screw it in back, it's just a very quick twist and snap kind of action. So it actually makes the whole process of transferring of the milk from different bottles become very easy. So why is it that Ms. Bock is so concerned and so adamant about having IP protection in place? It's because about 1 year into the initial design of her first prototype, right, she discovered that her design had been leaked and someone else was actually going to start mass producing her particular design. And at that stage, she had not actually started to register her designs or filing for patents because she actually wanted to understand the product better before taking the step. Now, the fortunate thing is that that particular prototype design wasn't this particular square container that she was looking at. So with that experience in mind, right, so when she actually started to come up with this square bottle design, she made it a point that even before going into any market, she had her IP protection in place first. Okay, so each time they come up with a new product, they will quickly follow up with a design and patent search and filings. And before entering a country, they will then ensure that their trademarks are in place. In fact, some of the times, right, they have actually held back their overseas launch in order to get their trademarks and patents and registered designs in place first. So she has actually gone the extra step, which is to say, if I don't have my IP protection in place, we are not going to launch the product. Okay, and this really is a very proactive step that she has actually taken for the company. So I really want to urge everyone that, don't leave IP as an afterthought. It's actually a very important piece of protection that you need to have in place at every step of your business. So we've talked about so much about IA and IP and how they are important to your business, right? So you might also be thinking, so roughly how much are we talking about? So this is just to give you an indicative range. So for a trademark in Singapore, for example, if you file for one mark in one class, it's approximately $1,000. So that's inclusive of what we call the official fees, which is the fees that are actually paid to IPOS, and the non-official fees, which is the professional fees that actually pay to get a trademark agent to actually help you to do this process. Then you might be thinking to say, is there something that we can actually file internationally? So the closest that we have to that is actually what we call the Madrid Protocol. And again, for one single mark in one class in one country, it's approximately 1,000. So if you want to file in multiple countries, you just need to kind of like multiply that by the number of countries you need to have protection in. So trademark, if you recall in the earlier chart that we had about the costing, right? It is one of the most expensive ones. So one patent in Singapore alone, it can cost you between about $10,000 to $20,000. There's no such thing as what we call an international patent, right? The closest one to that is what we call the Patent Cooperation Treaty. So it actually kind of like standardizes the initial filing stages of a patent application to make it easier for you when you enter the various countries. And again, within this gambit, for one invention, it's approximately about $10,000 to $20,000 per country. Okay. And finally, for copyright, that's probably one of the cheapest in that sense. The key thing about copyright is that you need to establish the time at which your copyright actually manifested. So when did a piece of work get reduced into form? So the way to do it is you can actually do it a lot easier these days. So through this website, which is called WIPO Proof. So WIPO is actually the World Intellectual Property Organization. They have this website where you actually can, put in your digital versions of your work. It doesn't actually get uploaded to their site. So what it provides is that it actually gives you a timestamp. Okay, so for a payment of about 30 Singapore dollars, you can put in about 20 different documents in there and then get a timestamp for each of these documents to say that, okay, this particular piece of work was produced at this point of time. So copyright, again, just remember, a lot of it is down to saying when this piece of work was actually produced. So that's a WIPO proof for you. You can just Google for that. I was told that a lot of you might be interested in about what's happening in Southeast Asia generally, right? So this is, it's a bit of a busy chart, but again, a very quick condensed overview about the patent situation in Southeast Asia. So in a lot of countries in Southeast Asia, they have what we call a patent and a utility model or petty patent or utility innovations and so on. And what that actually means is that whether it's a simple patent or utility model or petty patent, right, they are typically shorter in duration. So instead of 20 years, as you can see from the chart, some of them will be 7, some of them will be 10 years, some of them will be 6 years. So what's the reason for that is because this usually covers simple inventions, okay? And again, these inventions will be held to the almost the same kind of standard as when you're examining a full patent. However, there are certain allowances so that they are actually easier to get. So that means your simple patents are easier to get granted in these countries. So especially for, I would say, inventions which you feel that has got a very short life cycle, right? You might actually want to consider using this kind of simple patent strategy to say that, okay, I'm going to get my simple patent granted faster because the granting process is a lot easier, but your protection also will be shortened because it's no longer 20 years. So it's going to be 6 or 7 or 10 years, but that's all right because your product technological life cycle might be short. So you could actually consider about using this kind of simple patent model to actually help you to protect your invention in these certain countries. Another possible way that you can actually look at this is that you could file for a simple patent together with a full-fledged patent at the same time. And then you can actually convert your simple patent into a full-fledged patent later on. If you decide that actually, hey, this is something that I think will have a much longer life cycle and I need to have a full 20-year protection. Okay, so simultaneous filing of the two different kinds of patent is something that you can actually think about as well. And one interesting thing that I want to bring up is that Singapore actually has got a patent re-registration arrangement with Cambodia and Laos. So which means that a patent that's granted in Singapore, you can actually just get it re-registered very quickly in Cambodia and Laos without going through the whole application process in Cambodia and Laos again. So if you do have operations in those two countries and you need patent protection, you could file for a Singapore patent first and then get it re-registered in those two countries very quickly. Right, so this is a quick trademark overview in Southeast Asia. So as you can see, the languages that are required and then the estimated registration fees. So these are purely just what we call the registration fees, which is how much you actually pay to the trademark office. Okay, so this does not include your trademark attorney fees. And your average registration time, as you can see, ranges anytime from a couple of short months to up to 1.5, maybe even 2 years. And going back to patents, as I mentioned earlier on, patents is a much longer drawn out process. Typical time frame you're looking at is between 3 to 5 years. Now, I understand that a lot of you are probably in the ICT space, right? And you might be thinking, okay, so what kind of protection should I go under for things which are maybe more like, software related? Okay, so if it's your software code, so that means your source code or your object code, those are typically protected under copyright law. But if you want to look into the, patent protection, which we call this generally as computer implemented inventions, right? They are generally patentable in Southeast Asia, provided that the program makes a technical contribution to the invention. So if you see under Malaysia, Thailand, and Vietnam on the left, that's the kind of like the descriptor to say what is actually allowable. And then for Indonesia, Philippines, and Singapore, those are the kind of description to say that what's actually allowable. And Cambodia lies kind of like in between the two of them. So really what all this orange text means is that your computer implemented invention, that means something that actually need a computer to run, cannot be just purely a computer program. So your computer, when involved in the process, has to provide a technical contribution. Okay, so the computer cannot be a, by the way, I use this computer, then there are certain things that can be done. No, so it cannot be a by the way thing. It has to be a integral part of the invention. Okay, so that's basically for computer implemented inventions in Southeast Asia and different kinds of positions for different countries. So in summary, I would just like to say that, to increase your business's success, use your intangible assets, because really, if you have a strong barrier to entry, you can keep the company's products at a premium price for a much longer period of time. Number two, you cannot watch out for what you are not aware. So always carry out freedom to operate searches when you actually go overseas. Protect adequately those that matter to you. So know what your intangible assets are. It's not sufficient. You have to give them the necessary protection as well. And of course, use your intangible asset strategy as part of management decision. So again, my point is IP is not just about law. It's not just about the legal department looking into it. Different parts of the company has to come into this. So whether it's going to be management, R&D, your salespeople, and so on and so forth, everybody has got to be part of this whole process. Okay, I'm going to end my sharing with a couple of grants and initiatives that we have in place for Singapore companies. So in Singapore, we have this app which is called iPOS Go that was actually launched by iPOS last year. So if you go into Play Store or App Store and look for iPOS Go, you can download the app. So the app interface is what looks a bit like on the next two on the right side. So it allows you to actually very quickly search for trademarks which are similar to a mark that you intend to register. And within about 10 minutes, you could actually register your trademark in Singapore, and it tells you the approximate cost as well. Okay, so this is one of the ways that we actually try to help companies to get a trademark registration very quickly in Singapore. And onto the patent front, we understand that, because I mentioned that patent registration typically takes a long time, 3 to 5 years. And we know that a lot of technologies have got very short life cycles, especially things like, in AI and fintech and so on. So we launched this initiative, which is actually called the SGIP Fast Track. So what happens is that if you have an invention that actually qualifies for the SG Patent Fast Track, and this could be, anything that's related to fintech, Industry 4.0, AI, or technology with an environment or public health cost. So something that's related to food security, mitigating climate change, wastewater management, and of course, in this day and age, any therapeutic agents that combat COVID-19. So this can actually qualify under the SG Fast Track, IP Fast Track. So when we say fast track, we have seen examples in the past where a Singapore patent actually can get granted in as short as 3 months. So that's like a very, very fast compared to 3 to 5 years. And the best thing is that for this SGIP Fast Track, there is no additional charges. You don't need to pay any additional fees for it. You just need to qualify under some of those categories that I mentioned earlier on. Okay. And the bonus to that is that once you have a patent application in Singapore that has gone under the SGIP Fast Track, if you have associated trademarks or design applications that are associated with the patent, they can also go through the Fast Track as well. Now, so that's about for Singapore side. And if you want to expand into the ASEAN region, so we have something which is called the ASEAN Patent Examination Cooperation Acceleration for Industry 4.0 Infrastructure and Manufacturing. Quite a mouthful. So Aspect AIM for short. So Aspect AIM actually then allows you to file into different ASEAN countries, and the commitment is that you will get your first office action within 6 months. So 6 months as in when you file for a patent application, let's say in Malaysia or in Thailand, right? They'll produce or they'll actually come back with what we call a first office action, which is a response from the examiner to give you an indication about whether your invention can be patentable or not. And 6 months is actually very, very fast already. Typically, we will only see the first office action, after a year or so, or maybe even up to 2 years. Okay, so these are a couple of initiatives that Singapore and within ASEAN we have to actually help to accelerate the pace of a patent getting granted. We have also launched with iPOS what we call a dispute resolution kind of a scheme, which is called the Enhanced Mediation Promotion Scheme. So if you do get into any disputes with an external party, whether it's local or overseas, right, we do actually provide funding of up to 10,000 mediation per case. And this can actually cover anything from the mediation service providers fees to the lawyers fees and so on. So a couple of things that you need to take note of is that this has to be mediated in Singapore, and you must also allow what we call a mediator, a shadow mediator, to actually observe the mediation. So another additional mediator. So the whole purpose of this is that we want to train up more mediators in Singapore to be able to actually help with mediation. And the last thing that you want to take note of is also that you have to be agreed to be named publicly. So that means the parties in the mediation, you have to be agreed, although of course the settlement terms doesn't need to be made public. So of course, for this particular scheme, it's really to push Singapore as a dispute resolution hub. And that's why we have this scheme, which we're helping companies to actually offset certain costs in their mediation. But at the same time, we also wanted to be able to train a lot of mediation people to help with the future mediation needs in Singapore. Now, moving on to tax exemptions. This is actually taken from IRAS's website, right? So if you have an investment that you actually put in protecting IP you created in-house, right? The first 200%, 200% tax deduction is actually available for the first 100,000 that you actually spent in creating your IP in-house. And then for 100% tax deduction after the first 100K. There are, of course, inclusions here, which is basically your annual IP protection costs related to patent, trademark designs, and plant varieties. And the type of expenses that actually fall under this category can be for your official fees and your professional fees. Now, if you do have IP that actually in-licensed from a third party, likewise, you can have the first 200% tax deduction for the first 100K and then 100% for the next 100K. But do bear in mind that the 200% tax deduction excludes payments made for the use of trademarks. Okay, so for trademarks, the 200% doesn't apply, but 100% actually still applies. So again, this second line is actually IP expenditure that you actually used in getting a license from another third party. Okay, so I'm coming very quickly to the last couple of slides. I know we're running a bit short of time. So if you're moving overseas, we have what we call the Market Readiness Assistance Program, MRA by ESG. In short, your IP search and application, as well as drafting of merchandise cost, can actually be subsidized up to 80% of the cost, capped at 30,000 per company per new market. Okay, and from October 1st, 2021 until March, this will drop to 70%. And just to note that new market actually refers to a new overseas country where your operations there, your revenue there does not exceed more than 100,000. Okay, and of course your eligibility is here on the right. Typically this is kind of like the eligibility for a small, medium enterprise or certain criteria over there. Okay, so just to share finally, a couple of resources from IPOS International. We have a total of 15 business guides. So a lot of the content I shared today are actually taken from the business guides. So if you have any queries about, IP rights protection, IP creation, collaboration, and so on, please, use your mobile phone, scan the QR code, it'll bring you to that link. Or if you want to, type in bit.ly/IPOS INTL business guides to download this guides. And the final slide that I have is, we talked about a lot about intangible assets and IP today. So we can, if you would like to find out more or understand more about what is it that IPOS International can actually help you with your business and identify your intangible assets and so on, we have complimentary 45-minute chats. So again, scan the QR code, or you can actually click on the go to this link, bit.ly/IPOS INTL-IA chat. And with that, I've come to my last slide, and thank you so much for your kind attention. And I'll pass the time over back to Ying.
Thank you, Eric. I note that we are a bit overrun, but maybe we can just go through 3 Q&As if that is fine with Eric.
Sure. Yep.
Okay. So we received some questions from the audience. The first one is regarding IP, filing of IP and trade secrets. So in the process of filing IP, inevitably the companies will also be sharing some of their trade secrets.
Yes.
So under what conditions should the companies consider filing for the IP? And under what conditions should they keep it as a trade secret? Yeah.
Okay, so I think the key thing that you want to think about is that whether your invention can be easily reverse engineered. So if the answer is yes, then I think you want to keep it as a trade secret. If it's no, then you might want to think about going along the lines of patent. But of course, that's not the only consideration. You also need to think about whether your invention can be patentable. Okay, because if it's not patentable, then you don't have any other option but to actually keep it as a trade secret. The other consideration is, of course, the term of protection. For patents, as I showed earlier on, if it's a patty patent, it's going to be typically 6, 7, or 10 years. If it's a normal patent, it's going to be about 20 years for protection. Versus if you have a trade secret. Now, theoretically, in trade secrets, there's no expiration. It can actually go on forever. But of course, you need to be very careful about not divulging your trade secret to anyone at any point of time. The moment that gets leaked out, you have very little recourse in that sense. Okay, so I would say maybe trade secrets, you have to take a look at it more for protecting maybe subsequent improvements or evolution of an invention, which doesn't actually incur a lot of additional cost. And I would say probably for the last thing that you want to consider is also for patents, you can file a patent, but is it easy for you to identify who's actually infringing it? So let's say if yours is actually, your invention is for a method of production, and the method of production can only be observed in a manufacturing plant. Do you actually have access to the manufacturing plant? If you don't have, then how do you actually exercise your patent to say that you are infringing on my particular invention over here? So if you cannot prove that, then maybe patents is actually not the way to go. Yeah.
Okay, next question. He's asking about whether IP registration in Singapore would cover Myanmar region.
In short, no. Okay, simply because IP rights are jurisdiction nature, which means that having protection in one country does not mean that you have protection in another. And just to expand a bit on Myanmar, right? It's a bit of an interesting situation because Myanmar right now currently has just very recently passed their trademark law. So their patents and copyright and a lot of the laws are actually not in place yet. So for patents, particularly in Myanmar, what you can do is that if you have a granted patent outside of Myanmar, you can actually file a similar one in the country through what we call a declaration of ownership with the Myanmar Registry Office of Deeds and Assurances. The problem is that there is no examination process. And once you actually file that and they receive it and they say, okay, you're good to go, you basically then actually publish in the local Myanmar newspaper to advertise and tell people that you actually own this particular patent. But because there's no patent law in Myanmar, right? So you can't actually have any rights in that sense to enforce your rights in Myanmar. So the whole process is really just a show and tell to say, hey, I have this patent, but I don't really have the rights to actually go after anyone that actually infringes it. So that's for patents. So for trademarks, it's a very similar situation as well. So you will also go through the same process and say, okay, I'm going to register for this trademark, and then I'm going to publish in my newspaper to tell people that I actually have this trademark. There's been some developments over in Myanmar though, which is there's the soft opening of the Myanmar Department of IP, and under which the new trademark law will begin, actually just began in October this year. So under this new, I would say kind of an interim period, right? The current existing registered trademarks, you will actually need to transfer into this new system. So that means that you need to refile your trademark application again. And if you currently don't actually have any kind of trademark application or filing with the Myanmar side, and you actually want to file a new one, for this time period, you cannot actually file for a new trademark for the time being. So that's a bit of an interesting situation that we actually see in Myanmar. So waiting for things to unfold.
Okay. Actually, we have quite a few questions from
Sure.
the audience as well.
Okay.
Eric, do you have time?
Sure. Maybe you can take about another one or two more.
Okay, sure.
Yeah.
So there's one question regarding shared IP. How would someone go about registering a protection for a shared IP that maybe is owned by multiple parties?
Shared IP, I assume you're talking about, let's say if you, my assumption on the question is that you actually co-develop something together, right? Okay, so co-development in joint venture agreements, I would say, then you would say, who are the inventors in this case? And typically what we would advise is that it's better to actually have one single party own all the rights, and then the other party get, like, let's say a sole or exclusive license. Because when you actually have a joint ownership of a patent, what happens is that if disputes happens in the future, right, then you're going to be talking about who's going to continue to pay for this patent application, or that, if one of the parties decide that I'm going to exit this business in the future, and if one of the parties actually wants to go into a litigation case, right, then I need to bring in this other party which no longer wants to have this business in place to come into this litigation. So it's actually quite a messy process. So the ideal way to do this is actually to have one of the parties own, and to kind of like to execute the whole payment process, the whole registration process, the whole payment of renewals and everything. And if they want to go into any kind of business transactions, they can actually hold that, but also have a very exclusive arrangement with the other party as well. So like a exclusive license agreement with the other party.
Okay, thanks, Eric, for the answers. So maybe for the rest of the questions, can I suggest that the attendees reach out to Eric directly or participate in the intangible assets conversations with IPOS International to take it forward? Yep, okay. So maybe I can proceed to share some upcoming events from SGTech as well as some grants available. So we do have the SGTech Star Grant, which is jointly funded by Facebook and also SGTech. So it is meant to help SGTech members who are facing problems with COVID in their business to reskill their workforce to grow their business further. Yeah, applications have started already since 1st October. So do contact us if you need to apply for this. SGTech will also be leading a Singapore Pavilion at GeoConnect Asia 2021. So GeoConnect Asia 2021 will be a focal point for ASEAN geospatial industry. It will be covering, it will be ranging over 2 days and a platform for industry to develop the geospatial regional development. So eligible Singapore companies can exhibit in the Singapore Pavilion and enjoy up to 70% lead IFM funding supported by Enterprise Singapore. So do scan the QR code to register your interest. And we do have 2 upcoming events, a China business matching. So if you're interested, if you're in the area of blockchain and are interested to meet with China partners, you can scan the QR code to attend our event. And also a Kata webinar coming up on 3rd December as well. Yeah. So lastly, for all the attendees who still have further questions and want to reach out to IPOS International, you can take down the links over here. They are also pasted in the chat, so you can just copy them. Otherwise, SGTech will also be sending you a post-event email together with all the links as well as the PowerPoint deck, and you can refer to them as well. All right. So once again, thanks very much to Eric for the very insightful sharing today, and I hope that it has benefited everyone. Thank you, and see you at our next session.
Thanks, Ying, and thanks
Thank
SGTech
you.
for